I am born a free human being, a free man or a free woman, according to the documentation registration of a live birth, completed and held on record by the Canadian Minister of Health and Social Services, and attached to this declaration. I do declare the following in order to establish my recognition. This claim of recognition has been created to notify the executive powers of Canada concerning their limitations and abridgment of my natural rights and freedoms, my human rights. Whereas it is my understanding that Canada is a common law jurisdiction. All right, so many have this understanding, right? Many are claiming that Canada and America are common law jurisdiction, that they operate under the common law jurisdiction, and many people are making this claim. The Interpretation Act of Canada, duality of legal traditions, and application of provincial law. Article 8.1, both the common law and the civil law are equally authoritative and recognized sources of law, of property and civil rights in Canada. So it's very clear, right, in their own enactment, that the common law and the civil law are recognized sources of law. So common law operates as natural rights, better known as human rights. And civil law operates upon statutory creatures, statutory law, enactments, and regulations. So some people wake up to the fact that there's such a thing called common law, and that they have rights and freedoms under common law. And then they get out there and they make some videos, and they teach that your common law right exists under your religious right. They say common law operates as my Christian right, as my biblical right, as my religious right. And they'll go and they'll take the Bible and they'll try and teach you that, well, use the Bible to express your rights, and therefore you'll be free if you do this. The courts have already declared, and they've written, that belief, religious activity, and association is a protected right under the Charter, Section 2. Well, hang on a second. Judge, you made a mistake here. You wrote it's a protected right. It's not a right. It's a freedom. Under international law, religious freedom, not rights. And here he says it's protected under the Charter, Article 2. And for those who have a good foundation, and for those who have a good understanding, they realize right away when they read this, oh, it's under Charter, Section 2. Therefore, it can be limited and abridged. That's why it's a freedom and not a right. However, Canadian courts recognize that as a restricted right that is subordinate. Well, hang on, Judge, you did it again. It's not a right, it's a freedom. And it's subordinate to such reasonable limits prescribed by law as can be justified in a free and democratic society. The Charter, Section 1, the Supreme Court of Canada has been explicit that religious beliefs do not trump the right of the government to organize and regulate Canadian society. So the courts have already said, if you try and declare a religious belief to say you are not subjected to statutory law, you are not subjected to civil rights and civil law, well, the courts have said your argument is not founded. Your argument is not correct. Your argument will be pulled down. In the International Covenant on Civil and Political Rights, Article 18, everyone shall have the right to freedom of thought, conscience, and religion. So you have the right to freedom of religion. Article 3, freedom to manifest one's religion or beliefs may be subject only to such limitations as are prescribed by law and are necessary to protect public safety, order, health, or morals, or the fundamental rights and freedoms of others. So if you claim your freedom to religion, that freedom is subject to limitations. They can limit that freedom. And in the Charter of 1982, they put it under fundamental freedoms. Everyone has the following fundamental freedoms: freedom of conscience and religion. So for those who say that my religious right trumps the ability of the government to apply their laws and their regulations against me, your argument is not formed correctly and will not be accepted or recognized. OPCA litigants do not usually frame their religious arguments in the charter context, but that would be the appropriate approach for them to pursue the rights they say flow from their beliefs, rather than a bald declaration of religion-based immunity. That is not to suggest that such charter-based arguments will succeed, but they will at least be appropriately framed. Well, why won't they succeed? If you use a religion-based argument for your common law rights, why won't they succeed? Well, because it's not a right. It's a freedom that's been recognized under Section 2 of the Charter, and that freedom can be limited or abridged. Well, I really don't like that, and that just rubs me the wrong way. I believe in God, and I think my rights come from God. Therefore, I should be allowed to express my rights that I believe come from God, that are in the Quran, or that are in the Bible, or that are in any other religious book. Well, it doesn't matter what you believe, and it doesn't matter that it rubs you the wrong way. If you take the position that my rights exist because of my religious belief, or my rights are protected because of the biblical belief, well, you are standing on wrong ground. They'll teach you, they'll tell you, well, the preamble to the Constitution says Canada is founded upon the principles that recognize the supremacy of God and the rule of law. So look, Canada recognizes the supremacy of God. Therefore, they have to recognize my argument. If I claim my common law rights because of the supremacy of God, because of my religious belief, because of my biblical belief, well, they have to recognize it, and they will. Oh yes, they will. But that's unfounded. This passage has been the subject of occasional judicial commentary, most simply because various litigants have argued that the preamble makes any of Canada's laws subject to the supremacy of God. And that argument is not correct. Still talking about claiming your rights here. The preamble to the Charter provides an important element in defining Canada, but recognition of the supremacy of God placed in the supreme law of Canada goes no further than this. They're gonna tell you. They're about to explain to you. It prevents the Canadian state from becoming an official atheistic state. It does not make Canada a theocracy, and it does not allow you or permit you to call upon the supremacy of God, to call upon your religious belief, to call upon the Bible, to exercise common law rights, or to exercise fundamental rights. And if someone is teaching you and telling you that they do, that they permit you to exercise your common law rights, well, then they're teaching you a straw man. And they're teaching you an incorrect position. And you are going to get in trouble with the state party. Calling on your religious belief will not allow you to exercise common law rights, natural rights, which are known as human rights. Canada will unilaterally apply its statutory laws, its civil laws against you, only subject to the Charter. That's it. A claim that a relationship between an individual and the state is always one of contract is clearly incorrect. Aspects of that relationship may flow from mutual contract. For example, a person or corporation may be hired by the government to perform a task, such as road maintenance, but the state has the right to engage in unilateral action subject to the Charter. So what does that mean? Well, it means we're going to apply our statutory laws against you. We're going to treat you like a statutory creature, exercising civil rights, unless you can prove to us that we are breaching your charter right. And what's the Charter? Well, it's an expression of natural law. It's an expression of our human rights. And this verse here pulls down the second strongman, pulls down the second position that people are out there teaching, that everything is contract law. And you just need to tell them, we have no contract. Therefore, you have no control of me. And you can't tell me anything. You can't make me do anything because we're not in contract. But the law has says the state has the right to engage in unilateral action subject to the charter. So arguing the fact that there's no contract between you and the government will not work. They will unilaterally apply their statutory law, their civil law against you. There are those who are saying that the UCC is the way to go. If you file a UCC financing statement, if you register it in America, then you're going to get your rights back. You're going to be able to exercise your common law rights and your commercial rights. Oh, it's going to give you a whole bunch of imaginary money. You have all this money coming to you if you file a UCC. Well, UCC is commercial legislation that operates in the United States of America. It does not operate in Canada. And you can look at any court judgment on CanLII. You just type in UCC and you will see what the courts are doing and saying. UCC litigants can be charged with criminal activity and have been charged with criminal activity. And in addition to that, they are charged with levies and fines for filing these documents. And if you file a UCC financing statement and then send it to the CRA, you better get ready, because CRA is going to lay a very hefty fine and penalty against you. Talking about hundreds of thousands of dollars they're going to levy against you for this paperwork. The Supreme Court has made it clear that the common law must develop in accordance with charter values. A trespass in common law. All right, so you want to claim that your common law rights have been trespassed against. That Canada or the American government has trespassed against your common law right. Well, then go argue the Bible. Go argue your religious position. Go claim a UCC statement. Go claim contractual law, right? And it'll work, right? You're going to be free, right? Oh, only if you're deceived. Only if you've picked up a straw man argument. Because a common law trespass in law, it now equals an infringement or a denial of a fundamental right. And what is a fundamental right? Well, it's a human right. It's the new natural law. And on that topic, right, if you go to court and you start claiming you have natural rights under natural law, what are you telling the court? Well, you're telling them that I don't understand what's going on. Because you're not going to go there and argue natural law and natural rights. Because natural rights are now put forth by human rights. So if you're still using the old terminology of natural law and natural rights and common law, you're just showing the court that you don't understand your position. That you don't understand where you're standing under. So you open your mouth and you make a claim to the executive powers of Canada, whatever department it may be. And you say to them, well, Canada is a common law jurisdiction and I have common law rights in Canada. And you make that claim. But then when you go to back up that claim, right, you do it incorrectly. You do it with straw man arguments. You do it with operations of law that are not recognized by the state party and that bring forth no legal obligation upon them. Well, what do you think is going to happen to you? What do you think is going to transpire against you? So this is the first claim that is made in the claim of recognition. That we recognize that Canada is a common law jurisdiction. So we made a claim, right? And now we have to back it up with proper operations of law. Well, what are we going to tell them? Well, the Bible tells me so. Well, God said so. Well, you have no contract with me. Or you're going to hold them to their obligations. Well, in the charter, right, it brings forth our human rights. And in the charter, right, it allows me to exercise my human rights. And you're attempting to place a limitation, an abridgment upon those human rights by your civil law, by your statutory law. And you are not to do this. You have no authority to do this. International law is what controls your domestic law, Canada. And I have rights that are expressed in international law, my common law rights, my natural rights, now known as human rights. And they're expressed in international law, and they produce a legal obligation upon you. Now you created an enactment, a statutory power that is attempting to remove my human right. And that's non-founded. That's not correct ground. That's illegal. Every time you make a claim in law, attached to that claim, there has to be a corresponding obligation on the other party. And if you make claims that are unfounded in law or that produce no obligation upon the other party, then your claim is worthless. In your own mind, you may think, oh, my rights come from God. My rights come from my religious belief. My rights come from the Bible. Therefore, I have the right to argue and I have the right to make some claims. Yes, you do. Go ahead, make all the claims you want. But as you see tonight, those claims will produce no corresponding obligation against the state party. And if not, it's going to get you in more trouble with the state party. Because you're sticking up your head and you're trying to exercise rights that you don't know how to enforce. And they're going to drop the hammer against you. And same with the UCC. You drop a UCC financial statement upon a government body in Canada, and you're going to get yourself in a lot of trouble. Still talking about a claim of recognition here. So we made a claim that Canada is a common law jurisdiction, that common law rights are authoritative in Canada. And then we showed them, and we told them, where did we get this understanding? Well, the courts have said that common law operates according to the Charter, and that common law flows from international law into domestic law. So we made a claim, and we backed it up appropriately. We'll look at one more claim. Whereas I understand and claim that Canada is a signatory to the International Bill on Human Rights and Freedoms. So we just told them right to their face. We know, Canada, that you're a signatory to the International Bill on Human Rights. And that bill protects my common law right. That bill protects my natural rights. In the Immigration and Refugee Protection Act, Article 3.3F, the enactment complies with international human rights instruments to which Canada is a signatory. Alright, so we just showed them in the law, right? That we understand, Canada, that you are a signatory to human rights and fundamental freedoms. Whereas I understand and claim that the executive powers and the legislators are under obligation, legal obligation, to respect and ensure my individual rights and freedoms, as enumerated within the international covenants, the Constitution Act of Canada, and subsequent domestic law. Alright, so we just made a claim, right? Now we're going to back it up again. International Covenant on Civil and Political Rights, Article 2. We're not already provided for by existing legislative or other measures. Each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional process and with the provisions of the present covenant to adopt such laws or other measures as be necessary to give effect to the rights recognized in the present covenant. So the provisions of the present covenant bring forth our common law rights, bring forth our natural rights, bring forth our individual human rights. And Canada has to bring forth these rights in accordance with the constitutional process. Why? Well, the constitutional process is foundational law. It's primary law. And that's where human rights, that's where natural law exists. And that's why the International Covenant placed the obligation upon the state party to do so. The veto versus Canada. Canada's international obligations and relevant principles of international law are also instructive in defining the right. Well, why would it be instructive in defining the right? Because Canada is under the legal obligation to make sure that the common law rights and the natural rights, those human rights that exist prior to the creation of the state, that do not flow from statutory law, that do not flow from civil law, are contained within the constitutional process, are contained within the Charter of Rights and Freedoms, that we may stand upon these rights. So you make a claim, and every claim that you make is backed up, it's created, it's supported with proper operations of law. And this is the same for Canada and America. And that's how a claim of recognition has to be built. And that's what a claim of recognition does. It takes each right, each common law right, each natural right, each human right, and claims them, and then produces the operation of law that backs up the position that is claimed. So not only do you learn the right, and not only do you claim the right, but you also get the operations of law that backs up the right. You also get the operations of law that are produced in domestic and international law to show that you understand what ground you are standing on. So one of my subscribers sent me a video of this man teaching that the Constitution Act of Canada 1867 and the Charter of Rights and Freedoms 1982 have no force or effect, that they're imaginary documents, that there's no operations of law contained in them, and we should ignore them. And he cites the Constitution Act 1867, Article 2, where it says this provision has been repealed by the Statute Law Revision Act. The provisions of this act, referring to Her Majesty the Queen, extends also to the heirs and successors of Her Majesty, kings and queens of the United Kingdom, Great Britain, and Ireland. And then he reads that and he says, you see, it was repealed. Therefore, when Her Majesty the Queen died, when the first Majesty died, there's no successor. Well, have you ever looked into the law? Have you ever looked into the enactments? One specifically called Succession to the Throne Act. If you